Committee will come to order. Thank everyone for their indulgence as we went to vote. And at this point, the Chair will recognize the Gentlelady from the District of Columbia, Ms. Holmes Norton, for her 5 minutes.
Thank you, Mr. Chairman. Mr. Larson, ladies and gentlemen, this hearing might have been called damned if you do and damned if you don't. I want to congratulate you on the 30-day turnaround period for the waivers. I was interested in the 94% of waivers. It seemed a high number. How can you explain that number?
Well, we have a number of criteria by which we review the applications that come in, and the vast majority of the applicants are able to satisfy the criteria that we've laid out in our regs and our guidance. And again, I think it reflects a point I made earlier, that the goal of the waiver process is to ensure that employees that have this type of coverage are able to maintain it. So the high approval rate reflects kind of the criteria that we apply and the desire to maintain coverage.
So we don't have people left without coverage as we convert from one plan to, from one system or non-system to another.
That's correct.
The notion of transparency is a serious charge. So far, from what I've heard in this hearing, it strikes me that it is a bogus charge. But the way to show that would be to have you walk me through the process. So let's start when this bill was passed, because we're coming upon the anniversary. It was, I think, March 23rd or something of that kind. Now, you were in the, under the APA, of course, there's got to be notice and comment. And so the test of transparency is, what does the public know? What does the public, including those who are most affected on either side, what does the general public know? So you had to go into the public, into the Federal Register. When did you go into the Federal Register?
We issued an interim final rule with a request for comments in June of 2010. So
this bill was passed in March, and within 3 months you were within the Federal Register. You were in the Federal Register.
That's correct.
So people have almost immediate notice that they can avoid gaps in coverage. Now, let's go further. To test the charge of lack of transparency, did you publish any guidance documents that would inform someone who wanted to apply of how to apply?
We did. We issued the first guidance in September, I think it was September 3rd or 4th of 2010, also within 90 days of the issuance of the interim final rule. And then subsequent to that, we issued guidance in November, further clarifying the criteria that we had been applying. And then in December, 2 additional guidance on issues relating to disclosure and the new sales of mini-meds and the like.
Did all interested parties have the opportunity to submit comments? Were any complaints that you didn't keep the comment period open long enough?
Well, in fact, the guidance that we issued were, in many cases, in response to comments and concerns that we received, and we reacted to those and would issue guidance in response to the feedback we got from the public or employers.
Did you make adjustments based on the feedback? How would you characterize what effect the comment from the public had on the final regulation?
Well, one example of that is that there's concern over whether people know, for example, that their mini-med policies have annual limits when we grant a waiver. And so, for example, some of the consumer groups wanted to make sure that people who had these policies were given notice that their policies had limited benefits. So, for example, in the guidance that we issued in the fall, we indicated that people who receive waivers should make sure that they're providing disclosure to people who are covered under these policies. That's a good example of how we got input about public, disclosure of these, and then we put a guidance out reflecting that input.
Thank you, Mr. Chairman. Mr. Chairman, I just want to say, as I open my round of questioning, I think that what the witnesses just carried us through indicates that whatever problems you have with the health care bill, it is a completely bogus charge to allege that there was no transparency in this process, and I thank you.
I thank the gentlelady. The chair would now recognize the gentleman from Illinois, Mr. Walsh.
Thank you, Mr. Chairman. Dr. Hasemeyer, let me, and I know I butchered your name, I apologize.
That's okay.
Let me,
Not doctor, it's Mr.
let me have at that what my colleague on the other side just mentioned. Is this issue of transparency, is that a bogus charge as far as you're concerned?
Well, I really can't speak as much to that issue. I think maybe some of the others on the panel, maybe Mr. Wold could, because I'm not an applicant for a waiver. I haven't been through the process.
Thanks. Let me quickly go to you, Mr. Wold. Just opine. Is that a bogus charge, the transparency?
That's a tough question. I think as a benefits attorney, the transparency means something different to me than to maybe an employer who sponsors one of these plans. Given the fact, that I have access to information and have resources that aren't generally used by employers, and so from my perspective, we were able to follow the different pieces of guidance. I don't know, some of our employers, some of our clients had not heard anything about it until we informed them about it.
Okay. So. Mr. Larson, according to the HHS Annual Limits Review and Evaluation Standard Operating Procedures, HHS employees must specifically look for whether applicants are unions. No similar consideration is made for small businesses. And in fact, unions are provided two special criteria for flexibility. Criteria not given to other hourly wage employer groups such as restaurants, retail industry, or seasonal workers. Does Obamacare provide special consideration for unions and not for small businesses?
We, in implementing the waiver process, do not provide any special treatment for any particular type of applicant or applicants from a particular sector in administering the program.
Why were HHS employees instructed to specifically look for whether applicants are unions?
I don't recall that the standard operating procedures kind of describe it in that way. It may just be because we categorize whether they're Taft-Hartley plans or whether they're self-insured plans. So we categorize the type of applicant. But if someone is categorized as a Taft-Hartley or self-insured or a union plan, they don't get any different treatment, or there are no different criteria applied to them. So,
Mr. Hasemeyer, do you have a thought on that issue?
Yeah, it's a little far afield, but it's an interesting question. That's well, it's not far afield. It's tangential to this, but it's an interesting question. This particular statute is part of what is known as Title 27 of the Public Health Service Act, which was originally put in as part of the Health Insurance Portability Accountability Act in '96. And there is the question of regulating insurers and the question of regulating employer plans. Now, what's interesting about this is under prior law, HIPAA, ERISA, COBRA, et cetera, this regulation of whether an employer plan passes muster would have been the Department of Labor. And in fact, if you look at these regulations, they are jointly issued, as were the HIPAA regulations, because any of these Title 27s are, because of the joint jurisdiction, by HHS, Labor, and Treasury. The interesting question to me is how in that process did the administration suddenly decide that now HHS was going to regulate employee benefit plans?
How do you think that did?
I don't know. I mean, but it's an interesting kind of jurisdictional question that you might want to look into because, I mean, I know the people at the Employee Benefit Security Administration over at Labor. I've worked with them in the past, and that's traditionally where this kind of thing would go. I think Mr. Larson's answer that, yes, you have these different kinds of plans. There's the multi-employer Taft-Hartley Union Trust. I mean, these are things that department, that agency at Labor deals with all the time. Somehow in this jointly issued reg, several things happened that are, to me, quite surprising. You know, one, they took what was Congress's instruction to define a term, meaning to set a number, and they turned it into 3 numbers over 3 years, an escalation, and suddenly we're talking about a phase-out, which isn't in the statute. They then instituted a waiver process from that phase-out, which, again, as I pointed out, is not authorized in the statute in spite of Congress in 21 other places in the statute explicitly authorizing a waiver process. And now they've put the enforcement and the regulation not just on insurers but on employer plans with Mr. Larson and HHS, which is just contrary to the normal practice that we've had in the past in this area of law. So I don't know why.
Thank you. Mr. Chairman, I yield back.
Thank you, Mr. Walsh. The Chair will now recognize the Chairman of the full committee, the gentleman from California, Mr. Issa.
Thank you, Mr. Chairman. Mr. Larson, I'm still a little baffled about this question of if it doesn't matter if somebody's unionized or not, why would you put an SOP to recognize whether they're covered under a union contract? What is the purpose?
The purpose in setting out the categories is that depending on the applicant, for example, if an insured plan applies, you have premiums that are associated with the coverage. If you have, for example, a self-insured plan, or in some cases a collectively bargained plan, you will have premium equivalents as a
in Obamacare as a matter of law. Is that specified?
I'm sorry, what is your question?
I hear all of that, but the fact is that if you put into a waiver authority the information, then we have to presume the information was seen, and if the information was seen, it can have an effect on granting or not granting, right?
I wouldn't say that that's true. In the case of unions,
but the people approving waivers know who they're approving, and they know what their category is, right?
Well, they're aware of how the plans are categorized, but it doesn't impact how they review the
Let me ask a broader question. With all due respect, aren't we disenfranchising smaller businesses by granting waivers, which inherently are by those who are smart enough and can afford to come and do it? Mr. Hasselmeyer, don't we inherently have in this various application process not only things which are extra or outside the legislation and therefore not lawful to be done by the administration, and if they need to do it, they need to come back for authority, which they haven't sought. But don't we also have a situation in which we're inherently disenfranchising the vast majority who do not have a financial capability of coming and asking for waivers because the cost of going through the waiver process would be greater than the savings?
Well, Mr. Chairman, I did in my testimony, my prepared testimony, address that at the end and said there's a legal question, as we both talked about, as to whether the Department actually has the authority. But yes, there is this policy question of this kind of a waiver process in this or other circumstances where rather than drawing a line that anybody can look up and see which side of the line they're on, you're saying, well, come and ask us and maybe we'll let you know. Yeah, that will have at least the perception, if not the reality, of tending to favor those who are larger and better resourced than those who are smaller and less aware and less resourced. So yes.
Doesn't this committee and the Congress have an obligation under equal protection to find out, in fact, who the disenfranchised are and see that they are given equal opportunity? That's what public service announcements are all about, is trying to inform the public. Do any of you know of any effort by the administration to inform the employer public or the insurance public that they can receive these waivers and to make the cost of doing it de minimis? Is there any program of that sort?
Well, as I testified earlier, we put out the bulletins
A bulletin. Did
press
you know, I'm an
and the
employer.
press-
I'm an employer. Where would I have read that bulletin?
Well, what we found is that the 30% of the applicants that we processed were small businesses. They had 100 enrollees.
And where did they find out about this?
Well, we didn't ask them how, but I guess the point is that they were.
Oh, come
they
on.
were
You
able-
you advertise and then you say you didn't ask how? I've never seen anyone come in that they didn't ask, well, how did you find out about this program? So how do you gauge the effectiveness of your advertising? Or another way of, how do you gauge the effectiveness of spending the taxpayers' money?
Well, we're always open to suggestions for getting the word.
No, no, I'm not asking, I'm asking how do you do it?
How do we do what?
Look, Obamacare is an abysmal failure, and people are being hurt out there by rising health costs, and then there's a waiver program that seems to select winners and losers fairly arbitrarily. How do you defend that process, and more importantly, how do you know you're effectively reaching out to all of those who could be entitled to the lottery of can I opt out or not?
Well, it's a good process. We have 30% of the small businesses that are approved. We're able to maintain coverage for over 2
What
million
percentage of the
people.
American public has been approved? What percentage of these waivers, what do they represent in percentage of the insured America that's now wavered out?
I do know that these waivers account for about 2%, a very small percent of those who have employer-based coverage.
Okay, so is there anybody else here that sees a problem with 2% opting out on a program that in fact is not ready for prime time? That's a rhetorical question for which Mr. Hasselmeyer, if you would like to weigh in, I'm astounded that we're having a hearing and every answer is we don't know, we'll check into it, we think the process was fair, we don't have answers to that, we don't think that's true. I simply have one closing question. If only 2% have it, if there is no affirmative plan to enable small businesses, of which I have some, to avail themselves of it, then how can we feel that it's being done fairly for the 2% that are getting to opt out of, a great many of which are, if you will, the already advantaged groups of society? Yes, sir.
Well, I would say that that is exactly the kind of problem that this sort of situation creates, that it's difficult for anyone, Mr. Larson or anyone else enforcing this, to counter the perception that this is not the rule of law, that this is actually the rule of who you know. And that's why the whole mechanism, no matter how fairly or how generously one attempts to administer it, the entire mechanism is suspect in my view because of that.
Thank you. Mr. Chairman, thank you for shedding light on this problem of the 2% versus the rest of America.
Thank you, Mr. Chairman. Members will have 5 legislative days to insert comments for the record. I want to thank on behalf of everyone on the subcommittee and those who are not on the subcommittee but on the full committee that were gracious enough to join us. I want to join them in thanking you for your time and your collegiality and professionalism in answering the questions. The committee stands adjourned.
Because we're coming upon the anniversary. It was, I think, March 23rd or something of that
Yes.
kind. Now, you were in the, under the APA, of course, there's got to be notice and comment. And so the test of transparency is, what does the public know? What does the public...
Committee will come to order. Thank everyone for their indulgence as we went to vote. And at this point, the chair will recognize the gentlelady from the District of Columbia, Ms. Holmes Norton, for her 5 minutes.
Thank you, Mr. Chairman. Mr. Larson, ladies and gentlemen, this hearing might have been called damned if you do and damned if you don't. I want to congratulate you on the 30-day turnaround period for the waivers.
Regs in our guidance. And again, I think it reflects a point I made earlier, that the goal of the waiver process is to ensure that employees that have this type of coverage are able to maintain it. So the high approval rate reflects kind of the criteria that we apply and the desire to maintain coverage.
So we don't have people left without coverage. I was interested in the 94% of waivers. It seemed a high number. How can you explain that number?
Well, we have a number of criteria by which we review the applications that come in, and the vast majority of the applicants are able to satisfy the criteria that we've laid out in our.
As we
That's right.
convert from one plan to, from one system or non-system to another.
That's correct.
The notion of transparency is a serious charge. So far, from what I've heard in this hearing, it strikes me that it is a bogus charge. But the way to show that would be to have you walk me through the process. So let's start when this bill was passed.